Hello, and welcome back to Coin Lady channel. It's true that the SEC has had a rough go of it in the cryptocurrency market so far in 2023. In the end, 2023 was a triumph for the SEC. According to this news article, a judge has sided with the SEC and Terraform in a lawsuit involving the selling of securities. I'll keep you updated on the newest developments. All the raucous information comes from Stewart, the chief legal officer of Ripples. I have legal opinions from Jeremy Hogan and James Murphy, well known as Meta Lawman on X social media, among others. Some of the contents are questionable, but overall, it's an intriguing read. According to attorney Murphy, Judge Torres would have reached the same result if she had been responsible for this ruling, which is a significant element of the decision in this case. Curiously, the judge who sided with the SEC in this case at the year's conclusion previously argued against Judge Torres in a previous case, SEC vs. Ripple. Plus, I brought it up while we were talking. Some of the things this guy said here absolutely floored me. Just so we're clear, I don't come from a financial family or background. My counsel has nothing to do with money. Also, listen, you shouldn't base your investments on what I say. As a hobby and for fun, I enjoy making films on YouTube regarding crypto-related subjects. I'm just an enthusiast. Okay, let's simply set the table for a fast review. As of July 31st, this is the headline from CoinDesk. Judge Torres just ruled that XRP is not a security, and this comes only weeks after that. The headline reads, Judge denies Terraform Labs' request to dismiss SEC action, rejecting Ripple ruling precedent. With 2 bullet points to follow. In a federal court, Terraform Labs' request to dismiss the SEC case was refused. Plus the second, most crucial one. Additionally, the court stated that he would not be relying on a previous decision that found Ripple to have not broken securities laws when selling XRP to individual investors via an intermediary on an exchange. Judge Torres's ruling in SEC vs. Ripple is, of course, being cited. What made it all the more intriguing was the fact that the XRP community went into overdrive, discussing it after its release. I recall mentioning on my channel that attorney James Murphy had warned about this judge, named either Judge Rakoff or Akoff Jed Rakoff, many months ago, maybe even 7 months ago. Actually, he called this man a renegade. Plus, I'm not interested in reading the rest of the paper because of one section. On the other hand, Crypto published a story on August 3 titled Ripple's Chief Legal Officer Weighs in on Terra Ruling, which suggests that XRP is safe. It is worth noting that James Murphy, also known as Metal Lawman, was prepared to offer his thoughts on Judge Rakoff's judgment. Murphy brought up the fact that 7 months ago, he had referred to Rakoff as a renegade judge and had created a video. In addition, he made the observation that this judge, he has recently become somewhat famous for challenging the decisions of other judges. It's simply a trend for that guy. That's strange, because a pattern like that shouldn't exist. As a judge, you could find that concerning. So, what transpired in reality? As promised, the latest piece from Blockworks features a court taking a stand in the Terraform and SEC dispute about security sales inquiries. In a summary decision in favor of the SEC, Judge Jed Rakoff sided with the agency in its lawsuit against Terraform Labs and Dogecoin, the company's former chief executive officer. According to the ruling, Quan and Terraform were both involved in the sale of unregistered securities. Luna and Mir tokens are the main targets of the claim. The SEC asserted that Quan and Terraform participated in deceitful schemes to mislead investors by offering and executing transactions and unregistered security-based swaps. As stated in his writing, Rakoff granted summary judgment to the SEC. The defendants were charged with violating Sections 5A and 5C of the Securities Act by offering and selling Luna and Mir without registration on Count 4 of the amended accusations. There is no real disagreement that would make that coin stable. They're just continuing with the quote. Luna encased the fact that Luna and Mir are investment contracts makes them securities. Plus, he made it clear in the comment that his view of what constitutes an investment contract is legally enforceable. Only wrapped, Luna, and the previously mentioned Luna and Mir were determined to be investment contracts according to the Howey test. The SEC filed charges of fraud against Terraform and Quan in February, and now the trial will center on those claims. Justify, and this is an excerpt from that. We get this from the breakoff. The SEC has not challenged the defendant's contention that UST alone was not a security since buyers knew the value would stay constant at $1. But rather than make money, the defendant's efforts created the Anchor Protocol, where USD token holders may save their funds starting in March 2021. Quant himself publicly declared that the protocol will produce the market's greatest stablecoin return, with a target of 20% fixed APR. Therefore, I have always thought this idea was totally absurd, and now it has come to an end. The coin itself is steady, with a constant value of $1. Surely that isn't a security in and of itself. Consider this: you're making an investment, but you want to make a profit. This is all part of the Howey test. Therefore, you are free to argue this point of view. But I do believe that Jeremy Hogan, the attorney, made an excellent point. I will merely retrieve this. Right now, a stable coin cannot be a security, as Jeremy Hogan put it in his writing. If the price of anything is fixed at $1, how can you possibly make a profit off of it? On a per, what did the judge decide in the case of SEC versus Terraform Labs? If you can stake a stable currency for ROI at any time, independent of market conditions, we call it a security. So, give that some thought. Having the stable currency but seeing no return on it is a sign that you neglected to include something in the Anchor Protocol. It remains a safety net. Judge Rakoff exclaims, "What the fuck is that? Does it make sense in any way? Because of this, it isn't visible to me." That is why it is encouraging that Attorney Hogan is making that point. Judge Rakoff is 83 years old, the same age as my dad, therefore this image of him is likely older than the one he shared with the public. Attorney Hogan also wrote the following and sent the photo. However, we must have faith in their ability to comprehend modern technologies if we choose to nominate elders to the president. Do you agree? Does this make me an ageist or a realist? Well, I really don't think this man understands the technology. I am fully aware of the points. He doesn't seem to get us, in my opinion. Stuart Albright, Chief Legal Officer of Ripples, is this guy. His stance on the Terraform case's merits is unclear, he stated. However, with yesterday's decision, I have a couple of observations. First and foremost, the judge cares about the facts and will not condemn or even mention judicial tours as an example of the Ripple rule. Fit. Yeah. Alright, I guess we can take a break. Yeah, that's right. I mentioned at the beginning of the video that he did mention Judge Tor's rulings throughout the summer, but they are not part of this final rule. Okay, I get it. This guy is absolutely nuts, though. Thirdly, there will always be crypto ground wars with the SEC. A pursuit of political power, rather than good policy, is the driving force behind the futile endeavor of fighting token by token and protracted litigation. Attorney James Murphy, also known as Meta Lawman, offers his thoughts on the matter. So this is what he put down on paper. Just this morning, in the case of SEC versus Terraform, this occurred. The ruling by Labs Judge Rakoff is very consistent with Judge Torres's rippling decision. According to Judge Rakoff's ruling, Terra, the issuer, misled institutional investors into thinking that investing in Terra meant purchasing Luna, which is our company's stock, through written agreements. In other words, if you own Luna, you own a piece of the transaction fees that a network like Visa collects. Therefore, Terra was being very forthright in its claim that it was selling investment contracts. In fact, it was selling tokens as investments with the promise of yield through formal agreements. 10. It was reflected by the fact that investors receive a portion of the profits made through the Mirror protocol according to the amount they invested. In my view, Judge Torres would have reached the same conclusion with the Luna and Mir token sales that Terra provided to institutional buyers through written contracts, as beer holders are eligible to earn 1.25% on trading fees. The US dollar stablecoin was also determined by Joe Drake to have been sold as an investment contract. This was his decision based on the fact that UST was a stake in the anchor procedure. It was a security since it was an investment that could provide a return. Whether or not this decision can withstand an appeal is an open question. Oh, absolutely. I feel the same way. However, you would be exposed. Listen, I'm not trying to pass myself off as an attorney. There must be some way for this to make sense, though. Whatever the case may be, Attorney Murphy maintains that Hogan's observations were for that very reason. In the case of SEC versus Coinbase, I fail to perceive any significant influence from Judge Ray's decision. Assuming that Terra Coinbase did not enter into any contracts with token purchasers, it follows that Terra Coinbase did not issue any of the 13 tokens in question. Important note, Judge Ray's decision on UST lends credence to the idea that Coinbase staking service, along with any token at issue in the case that may be staked to receive yield, should be viewed as an investment contract, according to the SEC's expected arguments. I agree that the USD stablecoin verdict is up for debate. It's possible to gain yield on dollars, it happens constantly. That has nothing to do with the value of investments in dollars. I see. So, to reiterate, not only does it fail to generate investment contracts, but it is also not being done by everyone. Okay, then, he proceeds to list the 13 tokens that will be issued in the following section of the discussion. However, I have no intention of reading them. However, I happen to be the proud owner of a couple of those. Even though I'm not delighted with the SEC's attack, I do own a number of those. However, he subsequently states that, with the exception of January 17, the Coinbase hearing is a request to dismiss. This is merely one man's opinion, it is in no way intended as legal counsel. Thus, we will observe the outcome. If this whole thing is thrown out, it actually is conceivable. Although I can't say for sure, I have read and published on this channel the opinions of respectable lawyers who have speculated that this may really come to pass. And if I remember correctly, and I don't mean to paraphrase Attorney Deaton here, but if I do, he believed it was at least possible that it could happen. Therefore, I am unaware of his assessment of the likelihood of it. On the other hand, I seem to remember his saying something similar. So, the answer will be revealed in a few weeks. That's not my job description. Regardless of what I say, you shouldn't make any purchases or sales. Please like and subscribe my channel. See you later, bye.